Good afternoon, everyone. Welcome to the Appellate Division First Department. So you know the drill. Only ask for the time that you actually need. We have read your briefs. We are familiar with your arguments. The light is for you, not for us. First case, People v. Raymond Williams. 5, 2, and 5. D. Children. That matter is submitted. Tahari versus 860 Fifth Avenue.
For the appellant, 6 and 3, please. For the respondent, 7, please.
636. Cooper versus Bromes. Submitted. Cortlandt Street versus Bonderman.
Your Honor, for appellants, 2 of the Apex appellants, 7 and 3, please. There's a TPG appellants as well, also 7 and 3, Your Honor.
I can't hear you. That is granted. You'd like what? Oh, you're new to this jurisdiction, right? 6. He's a double digits, yeah, no. Yeah. 6 and 3, 6 and 3, and 6. Pope Investments versus Belmont Partners. Justice Owen, by the way, is disqualified on that matter. Yes, that is granted. Oh, another out-of-towner. 6 and 3, 6 and 3. People versus Holloway. That matter is submitted. DeVita versus NYY Steak, Manhattan. Six and 3, 5, 5 and 3. Oh, one more, I'm sorry. I'm sorry, you represent, you're Kimco? Kimco, right, okay. 2. 6 and 3, 5, 5, 3 and 2. Torres v. DiFilippo. You'd like to submit? No appellant. Matter submitted. Martinez versus Contreras, that matter is adjourned. B&M Kingstone versus Mega International, that matter is submitted. Taylor versus Enterprise FM, that matter is submitted as well. First matter on for argument is People v. Raymond Williams.
May it please the court, Tyler Goodcone is pro bono counsel under the supervision of the Office of the Appellate Defender for Mr. Raymond Williams. This court should vacate Raymond Williams' conviction of burglary in the 3rd degree because it is against the weight of the evidence. What's unique about this case is that the key evidence consists of videos that this court can observe in as good a position as the jury. The surveillance video capturing the 75 seconds Mr. Williams spent in the CVS from multiple angles refutes that Mr. Williams intended to steal rather than purchase the Red Bulls, and the only other evidence and testimony that could have led to a finding of an intent to steal. It's indisputable in that video that Mr. Williams enters the CVS. He picks up 2 Red Bulls, one in each hand, from the cooler in aisle 10.
Counsel, what about the defendant's confession?
Your Honor, Mr. Williams' purported confession is contradicted in every respect by the surveillance video. Mr. Williams was honest in his confession, but he was confused, and he was blatantly referring to a different event than that captured in the surveillance video in this indictment.
What event was he referring to in that confession?
Your Honor, he was referring to an event where he drank a Red Bull in a CVS, and that's People's Exhibit 10 at 15:07:50. Also, statements that he made during that interrogation video that did not happen in the surveillance video. He never put a Red Bull inside of a bag. He never took...
So that's uncontested, right? That the video here does not show that he put a Red Bull inside of a bag or that he drank a Red Bull in the store.
That's correct, Your Honor. Both of those points are uncontested. He also never took 1 Red Bull from the store. Rather, he picked up 2 Red Bulls that never left the store, and the store manager never told him to put the Red Bulls.
Can we just dial it back a little bit? The way I look at it is the first factor that I got to consider is did he know not to be in CVS, right? Because if you don't, I mean, right, that's a trespass, right? Plus, he has to have the intent to commit a crime. So did he know, or is there an argument that he wasn't trespassing?
Your Honor, Mr. Williams did not know, and I'd ask this court, in the interrogation video, it is very clear that Mr. Williams did not understand that the trespass notice applied beyond the 65th Fifth Avenue CVS where he received it to the 300 Park Avenue South CVS.
So, counsel, was the jury entitled to credit the testimony of the witness who testified that he explained to the defendant exactly what that notice meant? So was that an unfair thing for the jury to do, to accept that witness's testimony?
2 points, Your Honor. The first point is that this court has serious reason to doubt that witness's testimony. That witness, after reading from the trespass notice to the jury, which says that the only crime that someone could be convicted for is the crime of trespass under that notice, the prosecution asks him, did you tell Mr. Williams what crime could he have been subject to? The prosecution, or sorry, Mr. Nunez said shoplifting. He doubles down, the prosecution asks again, and he says no other crimes. He didn't properly explain the scope of the notice. It's also 4 months before this event, and Your Honor, I would ask that you look at the...
Not the scope, counsel. I think my colleague was asking you, did the witness testify that the trespass notice indicated that the defendant was not to go into any or all CVS stores? Put aside the intent aspect. Just let's focus on that, because if you don't have a trespass, you don't have burglary, right? So that's the problem right there that my colleague's asking. Did the witness testify that he told him you're not allowed to go into any CVS stores, and is the jury entitled to weigh that evidence?
Yes, Your Honor. He did testify to that. This court has serious reason to doubt that that is true. This court also, and I would ask that you closely inspect...
Why is that? Why would we have serious doubt?
For the reason that I explained, that Mr. Nunez improperly explained the scope of the trespass notice in saying that Mr. Williams could have, or that he's telling apparently people who are receiving these notices that they can be convicted of shoplifting.
But again, the question for me is one of credibility, right? The jury viewed the video surveillance. The jury was aware of the interrogation, the questioning. The jury was aware of the testimony. So why should we usurp the province of the jury in assessing the credibility of the witnesses? They made a determination.
Because, Your Honor, even if you credited Nunez's testimony, the interrogation video makes very clear that Mr. Williams did not understand the scope of the notice. Even if you
And the jury saw that video, right?
The jury saw that video.
And maybe they didn't come to that conclusion. Is that fair?
Your Honor,
Again, so the question is, why should we upset? The jury saw exactly what we all saw and you saw, and they made a determination about credibility. And the question is it so out of the realm of possibility that that credibility determination should be overturned?
Your Honor, this is not a credibility case. Again, the key evidence in this case is the 2 videos, and I would submit that the video does not show that Mr. Williams and actually rejects that he intended to steal, in particular, the surveillance video.
Counsel.
Thank you. You have time on rebuttal.
Thank you.
Your Honors, and may it please the Court, Anna Nachik for the people. Defendant's conviction for third-degree burglary should stand. The jury...
I have a question. So let's say that he committed a trespass. That in and of itself is not a burglary, is it?
Correct, Your Honor, however...
So then he's got to do something other than just trespassing. He must have committed a crime inside the premises?
He must have the intent to commit a crime inside
Okay,
the
so how do you
premises.
show that he had the intent to commit a crime?
In two ways, Your Honor. First, through the surveillance video footage where defendant is repeatedly looking over his shoulder to ensure that he's not being watched.
How do you know that?
You don't know why he's looking over his shoulder. I mean, maybe, I don't know, he's paranoid.
And in
But
addition-
you can't say that that's because he's, about to commit a crime.
And in addition to that, when I was looking at the video, to be quite honest with you, not knowing who the defendant was, there was another person, another patron of that store that did the exact same thing. Looked over his shoulder. So I suppose you're not arguing that someone that goes into a CVS and looks over their shoulder, even at the register, is there to commit a crime, right?
No, Your Honor, that has to be taken in conjunction with
With what?
with also the fact that he knew he was banned from any and all CVS stores.
That he
And-
knew that? That's belied by his confession, alleged confession.
But also, counsel, that would go, again, to the trespass. It would not go to the entering with the intent to commit a crime. That could be, oh, I know I'm not supposed to be here, and so I'm looking to see whether or not the security is following me or sees me because I'm not supposed to be here. It doesn't necessarily link up with an intent to commit a crime.
Well, Your Honor, we would argue that that has to be taken in conjunction with his confession.
Okay, I'm taking that into conjunction as well. What else is there? Oh, so the confession. And in the confession, his statements seem to be a little disorganized or confusing because he does make reference to having consumed a Red Bull, right? And there's nothing on the video or any testimony that there was an empty Red Bull found at that CVS or on his person, or that he was observed drinking a Red Bull?
There is no testimony, and it's not in the video, that he consumed a Red Bull. However, we would argue that
Is that a conceded point, or are you arguing that?
it
That
is
he did not drink a Red Bull in this instance?
There is no evidence on the video that he drank a Red Bull in the store.
Is there any evidence that he tried to conceal any Red Bull?
What happens in the video is that defendant removes 2 Red Bulls. There was testimony at trial that security was called to the front, and after security was called to the front of the store, defendant began to walk up to the front of the store.
But my question was, is there any evidence that he tried to conceal the Red Bulls?
By putting them in a bag or something like that,
Yes.
no, there is no.
No, the video doesn't show any of that.
The video does not show him attempting to place
The
Red Bulls
video
into a
shows
bag.
him walking, after he gets the Red Bulls from the refrigerator, walking past the exit, as the exit doors open, and there's a patron going out the exit doors, and yet the defendant does not walk out.
He does not walk out of the doors.
And what does he do? He walks to the self-checkout register, correct?
He never gets to the self-checkout. He
But
pauses.
he doesn't walk out the store.
He does not walk out of the store. However, at that point, security had already been called to the front of the store. There is also evidence on the video that Melina, who was at the front of the store, she's wearing a white shirt, she is checking to watch him as he's walking down the aisle. At that point, evidently, the jury concluded defendant knew that he had been, that security was...
What is the proof of the larceny? What is the proof that he was in there with the intent to commit a larceny?
By his behavior within the store and also his confession, where he admits that during the second week of January, yes, admittedly, this was January 19th.
How many incidents did he get arrested for?
That he was arrested for...
Yeah, well, what does the complaint say?
The complaint is just this offense.
No, the complaint is 2 offenses.
Yeah.
One in one CVS store and another one in this particular CVS store at 300.
Yes, but the trial was only on this CVS.
Exactly. But the interrogation was about 2 incidents in 2 separate CVS stores. And it was conflated. There was no separation of, I'm going to question you about this particular incident, and now I'm going to question you about this other particular incident. So when the officer is questioning him about 2 incidents at the same time, well, there can be confusion created.
There can be confusion, however, they were in different locations. The
I
second
understand,
location...
but he only got indicted for 1.
Correct. So what we would argue is that Vargas clearly says that during the second week in January, you were at the CVS store at 300 Park Avenue South. That's when he admitted that he
he was being asked about the first one and the second one at the same time.
Yes,
And he was given answers as to both.
yes.
And now, his confession, when you compare it to the video, you do not see him drinking anything, and you do not see him putting anything inside his bag.
That is correct. However, during the interrogation, right in the beginning, Vargas says, so during the second week in January, you were at the CVS store at 300 Park Avenue South. He nods his head. So evidently while he may be misremembering some details, he is talking about this instance. And yes, we admit that he did not drink a Red Bull in the store. However, he did admit in the video that he took 2 Red Bulls.
From which of the 2 stores?
We would argue that he was discussing.
You can argue all you want that it was from this one, but the video shows that it wasn't from this one.
Well, taking that in conjunction with his activity in the store, we would argue that the jury was right to find that defendant was guilty of third-degree burglary.
Thank you. Thank you very much. So I believe Justice Mendez had a question for you.
Yes.
I wanted to know where is the larceny? Where's the larceny?
Your Honor, there isn't a larceny. Again, I believe the surveillance video here rejects an intent to steal. He makes no attempt to conceal the Red Bulls in his pockets or the bag he was carrying. He doesn't linger in the aisles or scope out the stores. Instead, he walks calmly toward the front of the store, not even looking at the exit as he passes it.
Didn't the video show him looking in the store, like going up and down outside the store, or maybe?
Your Honor, that did not happen in the surveillance video.
I thought there was something about his being outside with a white plastic bag, walking up and down.
Yes, Your Honor. So he walks by, but he never looks inside the store. He simply walks by the CVS and then a few moments later enters the CVS.
Is that of any moment, even if that's true, that a human being walks by a CVS, looks in, bypasses it, and then comes back, there's an intent to commit a larceny in there?
Your Honor, I would argue that we've all done that 1,000 times. He then places...
Although we're all not barred from all the CVSs, right? We're not told that we're barred from the CVS. We don't go into the CVS after we've been told that we're barred from the CVS, or at least if that's what the jury believed, right?
Yep.
That's correct, Your Honor, but I would add that in totality, if you look at Mr. Williams' conduct, in particular, as he's walking past the exit toward the front of the store, another customer is exiting. He does not take that opportunity to try to follow that customer out.
But counsel, these arguments were all made before the jury. I have, right? I mean, these arguments that you're raising before us now were made before the jury. The jury considered all these arguments and rejected them.
Your Honor, this court is in as good a position as the jury to observe these 2 videos. It's not a credibility case. This court can weigh and see the jury got it wrong.
I'm not saying it's a credibility case, but the jury had, okay, I got it.
Well, I am saying that to some extent it is an issue of credibility. The jury is assessing the credibility, and the jury is assessing the evidence. But thank you both. And thank you, counsel. I see that you're doing this pro bono.
Yes.
We really appreciate it.
Thank you for your
so
time.
much. Tahari versus 860 Fifth Avenue Corp.
Good afternoon, Your Honors. My name is Menachem Kasten with the firm of Coase & O'Connor, representing the cooperative corporation here, as well as the 14 individually named defendants who were or are current or former members of the board, who in the complaint are all lumped together after just residing where they reside as the individual board members. Throughout the 173-page paragraph complaint, there is absolutely not one allegation of any tortious act committed by any of these 14 individuals. Under the many cases by this court, that is improper, and all 14 members have to be dismissed from the complaint. You can't just lump together 14 people and then just go through 173 paragraphs just saying the individual board members did certain things. Therefore, they have to be should be dismissed from the complaint. This appeal presents the application of the Lewandowski rule in the context of an unprecedented massive project, the likes of which this building, or any co-op building maybe for that matter, has never experienced, that would affect the daily living condition of every shareholder in the building who would be living in a construction zone for at least 2 years, and that would require that the courts micromanage this project. This is a $32 million project, which will take 2 years to complete. It will encounter placing 2 penthouses, glass penthouses, on top of this landmark building across the street from Central Park, would have built into it an internal elevator, which no one else has. It is a landmark building, as I said. It would require a hoist going up and down the building to bring material. It would require covering a line of windows in the building as the hoist goes up and down to protect those windows. It would require closing a street. It would affect building services. It would disrupt the freight elevator usage. It would just disrupt the daily living of 165 families living in this building. Under the House rules, specifically at page 159, the consent is needed to do any alteration in the building. The House rules provide that the board can withhold consent at its sole discretion. As Judge Oing would know from the Venetti Casino and Hotel case, where he was affirmed unanimously by this court, where you have sole discretion in a document, that is enforceable, and it overrules any kind of good faith and fair dealing requirement. However, in an attempt to work with Mr. Tahari, the board engaged in long negotiations with Mr. Tahari to get this project done. Under the leading case of Lewandowski, there is a presumption of propriety of the actions of a board.
So assuming that's true, the claim against the 2 board of director members who are affected by their view or whatever, in a pre-answer motion to dismiss, that would be enough to overcome the initial assertion of the business judgment rule, which is exactly what happened here. I'm not talking about the other board members. I'm talking about the 2 who have a direct personal interest, didn't recuse themselves. At a pre-answer motion to dismiss stage, it would be hard to dismiss that claim.
Your Honor, respectfully, you need to plead a tortious act committed.
Yeah, the tortious is they breached their fiduciary duty to the other members by having a personal interest and not recusing themselves. That is a tortious act. And this, again, is a pre-answer. This is an amended complaint, right? And well, okay, it's a long lawsuit, I'll admit.
173 paragraphs, Your Honor.
This is not a summary judgment motion, right?
Your Honor, I agree with that. If I may just add to that thought, and I hear what Your Honor is saying, by that reasoning, any member in the building who would be affected by a slow freight elevator.
That is exactly what Lewandowski says. Any board member who is personally affected doesn't get that broad sort of business judgment rule coverage.
I hear what Your Honor is saying, respectfully. I believe that that is not a discrete, tortious act committed by them, but I've heard Your Honor. Okay. And we know that conclusory allegations in a complaint can't sustain the complaint, as this court held in Chan, in O'Hara, in Hanto 88, Peacock, Pelton, Conrad. There was a slew of cases that conclusory pleading buzzwords like bad faith, buzzwords like wanton and willful don't carry the day for the plaintiff. Really, if you look at the complaint, we hear throughout the brief that he was being treated disparately to other shareholders. But that is not what he is pleading. Page 370 of the Record on Appeal is a chart made by Mr. Tahari where he's comparing the present requests to the 2005 agreement. His claim is not disparate treatment vis-a-vis other shareholders. His claim is disparate treatment as to the good deed you did for me in 2005 agreement. That doesn't meet the requirements of the law. That is not violative disparate treatment.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Y. David Scharf of Morrison Cohn for the respondent, Eli Tahari. The appellant seems to think that Lewandowski is magic pixie dust, that sprinkle on a case and the actions of a condo or a co-op board, and somehow it's absolved from judicial review. Well, this court has addressed this issue, and the motion court got it right. If we look at the record at page 288, the motion court said, as this court strongly believes that the business judgment is not completely unfettered and absolute, but is rather subject to judicial review for reasonableness, giving proper deference to the board's knowledge, experience, and rights. And the court went on and then said the motion to dismiss is denied because that is consistent what this court has said in Smuckler and in Stinner, because we have clear allegations, not conclusory allegations of disparate treatment. That disparate treatment relates because this case is not, as Mr. Kastner says it is, about all this tremendous project, which they called the Frankenstein or penthouse that they've created, because this case has nothing to do with that construction, which was all subject to the 2005 agreement. This case is about one simple act of denial, which is the combination of two penthouses, A and B. And the allegations of the complaint are crystal clear, and we enumerate all of the A and B combinations that have happened. We articulate the fact that all of these A and B combinations that have happened did not require the parties combining their units, A and B, to pay penalties of this nature, to have language limiting the concept of how long it will take them to do something.
But those other projects, were they as extensive as this particular project?
The answer is probably not. However, the notion that those projects are as extensive are bounded only by virtue of the fact when one compares it to the 2005 agreement. We are not before this court, and we were not before, and are not before the trial court, talking about the 2005 agreement. That's the subject of the arbitration, which is not—
So let's start with 501, right? How do you distinguish this case from Moltisanti, which basically is on all fours and says, no, not a disparate treatment of shares case? I don't think you can.
Well, Your Honor, because Piplowitz and Smolinski and Wapnick talk about the notion that when one shareholder in—
No. You can't. We just held in 2017 in this exact type of situation that you cannot plead a case, a claim under the BCL 501. So I don't know how you get out of that. Let's talk about breach of fiduciary duty. They don't owe you. None of those board members owe your client a fiduciary duty. So where are you getting a breach of fiduciary duty claim?
The corporation and its board members owe a fiduciary—
If you allege a separate, independent, tortious act, And I've already covered the two people who have a personal interest. What are the other individual tortious acts that you are alleging of the other board members?
Individual wrongdoings by the other board members. Where are those allegations?
As Mr. Kastner said, they are all affected by the slow service elevator when they are going to be allowing this to happen. Every combination of penthouse A and B was subject and was permitted to use the freight elevator. They have all said no, because for one simple reason, because they don't want the 2005 agreement to be enforced.
And you're alleging that that is the separate tortious act by individual board members?
That they are seeking.
That's what you're basing your breach of fiduciary duty claim on?
It is based upon, and I understand we disagree, that on the cases on the 501c, that we do have a fiduciary duty claim, but.
Assuming that I don't agree. I'm assuming that the First Department is held differently.
I'm working with that. What they have done in seeking to basically avoid the approval from the 2005 agreement, each and every one of them who has systemically and systematically gone about trying to cause Mr. Hari to abandon a project, the rights that were granted to him, and trading that back and seeking to make him abandon the project, that is tortious. That is a breach of fiduciary duty to him as an individual shareholder. And that is a breach of fiduciary duty that they have an obligation to uphold their contractual obligations of their predecessors.
And have we ever held that? Is there any case here in the First Department which has held that?
No, Your Honor. No, Your Honor. But that is why the trial court looked at this case, and I will conclude with this remark, that because we are dealing with this on a pre-answer motion to dismiss, where there are various causes of action, including a breach of contract, including breach of fiduciary duty, and discovery has been proceeding, that we should address these issues on a motion for summary judgment or a trial as appropriate.
Thank you.
Thank you.
Your Honors, 501 and breach of fiduciary duty I don't have to cover. The misrepresentation claims, the third and fourth causes of action, clearly do not meet 3016B. They were done, emails sent during negotiations. The law is clear. You can't rely on an adversary's email or statement. There is no privity, as under the Parrott case under the Court of Appeals. There are a slew of reasons why the two misrepresentation claims have to fall. On his, Mr. Scharf's reference to Smuckler and Stinner, both of those cases, Smuckler was a case where they denied him his request because he had litigated against the building before. Stinner was a case where they passed an amendment in order to take away the person's roof rights. Those are cases where there is something showing an actual act. And the combination of apartments like others, I said it in my, at the beginning, he's not looking to be treated disparately like other people. Otherwise, get this project done in 6 months. Everybody in the building's got 6 months. You've got 23 months that we're negotiating to get this done. You are in a better position than other shareholders in the building, and you can't come here crying disparate treatment. Finally, he talks about we tried to get him to abandon the project. We could have pulled the plug on day one under the sole discretion provision if we wanted to do that. We didn't do that. That shows good faith on our part. In conclusion, the real fact here is on page 703 of the Record on Appeal, where Mr. Scharf says that we're pulling the project because of COVID and because the real estate market is not what it looks like, and because it's not going to be accretive to his clients within the next 5 years. That's really what's going on here. We were negotiating back and forth. We were at the door of getting a deal done. We were holding on the risers that they made a representation that they had made an application to LPC when they didn't. That was the only thing holding us back. And then 703 of the Record, COVID comes, and he makes it very blatantly clear. The market has hit the wall, and therefore it doesn't make sense to do this project. Your Honors, we ask that the court reverse the court below, please. Thank you.
Thank you. Thank you both. Cortlandt Street versus Bonderman.
May it please the court, Robert Fischler for the two Apex appellants, that's Giancarlo Aliberte and Apex Partners LP, which is referred to in the briefs as Apex New York. Your Honors, I hope to focus my argument today on the two alter ego claims, starting with Apex New York. The alter ego claims against Apex New York are baseless. Apex New York was not involved in the notes transaction at issue here. It received no proceeds of that transaction, and it had no relationship, none, with the Hellas entities that issued and guaranteed the notes. The alter ego claims against it are frivolous. It never should have been in this case, and it should be dismissed from the case now. It is no wonder, in light of its non-involvement in the transaction, that the post-discovery, we're talking about an amended complaint that was filed after some 30 depositions, hundreds and hundreds of thousands of pages of documents produced, multiple interrogatories, etc. Even though the plaintiff had all that discovery before it filed the amended complaint, that pleading is devoid of a single particularized allegation against this entity, Apex New York. Just as an example, on the complete domination element that the Court of Appeals has characterized as a key element of alter ego liability, there is not a particularized allegation of common ownership, commingling of funds, overlapping officers and directors, any of the typical factors that this court would look at in determining that element.
So, counsel, I mean, the Court of Appeals found that the allegations were sufficient in the last round of this, and they're only more detailed now. Do you really honestly going to argue that we should dismiss them on a motion to dismiss?
I am, Your Honor, and I would
All right,
argue that
okay.
I would submit
I would move on to another part, because the Court of Appeals has already looked at this.
May I just simply point out, Your Honor, that the Court of Appeals was looking at a pre-answer, pre-discovery pleading.
Okay, and this is now even more detailed, not less detailed.
Not against Apex New York. The Court of Appeals did not focus on that entity, Your Honor. And if you look at the Court of Appeals allowed a degree of group pleading because it was pre-discovery. Here we are now, all the discovery I just described later. And
I thought that they, in a roundabout way, because I thought that they said that Alberti and who's the other one, Caprisi or something,
Caliche.
adopted the scheme, or adopted the corporate scheme. Yes. So aren't they kind of in a roundabout way? Are they not opining on this in terms of the alter ego theory?
I want to make sure I understand the question, Your Honor.
So you stated that the Court of Appeals did not specifically speak to Apex. Is that correct?
To this entity that's the appellant today, Apex
Right,
New
but
York.
they did talk about Caprisi and Alberti.
Aliberte. Yes.
And so in a roundabout way, they said that Alberti and Caprisi did adopt the corporate scheme. So isn't that, to some extent, opining that there is a merit to the alter ego theory?
No. First of all, Aliberte is not employed at Apex New York. He was with the London entity, a separate affiliated entity that was involved in this transaction. What we're now talking about is an entity that had no involvement in this transaction whatsoever, and against which there's not a single particularized allegation.
But again, the allegations were that they adopted the corporate scheme, and that they, and they also created the, I guess, the corporate shells in order to further that corporate scheme, right?
which is no longer an allegation today. The allegation today is that the offering memorandum issued in connection with the notes contained fraudulent misrepresentations. Apex New York had absolutely nothing to do with the issuance, the preparation, the dissemination of that offering memorandum. Either did Aliberte, for what it's worth, but this is a different set of allegations than the Court of Appeals looked at. And here, the Court of Appeals allowed a degree of group pleading that the Principia case in this court really forecloses at this post-discovery phase of the case. So I do think that there is a fundamental distinction between what the Court of Appeals held and what this court should do with this complaint. Very quickly, if I could just turn to the claims against Mr. Aliberte. First, there are 2 points that I'll raise. We have a number of others in the briefs. One relates to the jurisdiction decision from Justice Reed. The other pertains to the Walkowski versus Carlton standard set by the Court of Appeals for alleging an individual is liable for alter ego. In order to allege an individual's liability, it is clear based on Walkowski as applied by this court that there must be allegations of individual domination, including shuttling personal funds in and out of the corporation without regard to formality and to suit his immediate convenience. That language is right out of Walkowski. This court applied it in Art Capital Bermuda, Retropolis, and a number of other cases we've cited. With respect to the jurisdictional issues regarding Aliberte, first, Justice Reed erred in holding that he was subject to close relationship jurisdiction because the entire holding was based upon the fact that Aliberte signed the notes and indenture in his capacity as a director. That is an unprecedented holding. It also creates a number of due process issues, which we have briefed in the briefing, which indicates that where you have no minimum contacts, the element of fair play really is not met here, where if Justice Reed's decision is allowed to stand, Aliberte, who is a lifelong European resident, would be forced to, would be hailed into a New York court to defend these claims based on a form selection clause in an indenture that he signed in a representative capacity, but played no role whatsoever in negotiating, drafting, or disseminating.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Paul O'Connor from the Kasowitz firm on behalf of the remaining TPG-related defendants in the case. I'd just like to start out by noting that in order to try to ease the burden on the court, as we did below, we sort of divided up some of the issues here, and TPG defendants joined in a number of arguments that were made in the Apex briefing. That's at pages 40 to 44 of our opening brief, and I would just like to, I'm going to rest on that and not repeat what Mr. Fischler said on behalf of the Apex folks. But I do want to emphasize that Mr. Caliche is in exactly the same position as Mr. Aliberte is on the Apex side, Mr. Caliche on the TPG side. Mr. Caliche is also a European. It is not alleged that he had anything to do personally with the recap at issue here. It's not alleged that he either wrote or even reviewed the allegedly fraudulent offering memorandum, nor that he sold, marketed, or was otherwise involved with prospective investors. Neither is it even alleged that he is a Hellas shareholder or a Hellas owner. And as counsel for Apex just noted, controlling Court of Appeals precedent has made clear as to individuals in Markovsky applied by this court in Art Cap Bermuda, Souverain, and in the Stryker case, assuming that New York law applies here, which I'll get to in a second. Alter ego cannot be pled against individuals like Mr. Caliche, absent allegations, wholly absent here, that they were shuttling personal funds in and out of the company. That's not alleged. It didn't happen. Case closed, I think, on Mr. Caliche. And with case closed on Mr. Caliche, I'd like to move to the TPG entity defendants. There are a number of them here, but that doesn't change the fact that if you look at this gigantic 73-page, 259-paragraph complaint, done again after years of discovery, some 30 depositions taken almost exclusively in Europe, millions of pages of documents produced from TPG-related entities files, Apex-related entities files, third parties. There is absolutely nothing in the complaint about any of the TPG entity defendants specifically. What they do is they lump TPG and Apex together, call them a consortium, and move on from there. And as Mr. Fischler mentioned a minute ago, that type of group pleading has been held by this court, including very recently in Principia and in Art Capital, to be inadequate to plead a claim for alter ego. And again, that's pleading a claim for alter ego in a pre-answer situation.
Again, that was addressed by the Court of Appeals in a prior appeal on this, and they specifically stated that that was not a bar to the claims, the group pleading allegation, right?
Well, with respect, Your Honor, I don't think so, because that was, again,
I mean, I read the Court of Appeals decision, didn't you?
I did.
And what do you
Probably
think
less
is
happily
different
than you,
now?
but yes, I did read it.
What do you think is different now?
Years and years of discovery. What we know now is a lot more about, we know a lot more about what happened. They know a lot more what happened. They chose to amend the complaint, so they took all that discovery. And again, nothing about Mr. Aliberte, nothing about Mr. Caliche commingling funds, because they didn't, shuttling money in and out, and absolutely no mention of any of these 9 individual defendants. It's basically ripping up all of the case law from this court and others that says that group pleading doesn't get you an alter ego claim. I don't believe what the Court of Appeals was trying to do is create a brand new law. What they were saying is in the early stages of that case, with the allegations that were there, for that complaint with that group of defendants, and again, we've got a different complaint, different allegations, a slightly different group of entities in the case. And again, if you look at that complaint, if you're going to hold any of these folks in the case for alter ego, you'd have to put a cite next to it. And there is nothing to cite, because there's
Counsel,
absolutely
before you
nothing
run out
there.
of time, could you address the choice of law in terms of New York law? Why does New York law apply?
Sure. You're talking about whether Luxembourg entities should apply the alter ego claims.
Exactly.
Absolutely.
Yeah.
So Luxembourg law clearly should apply here. There's no reason for it not to apply here. Again, it is crystal clear that on an alter ego claim, the starting point is the law of the jurisdiction where the entity is located. That's Luxembourg here. We're trying to pierce the veil of 2 Luxembourg-Hellas-related entities. That is absolutely crystal clear here. There's no question about it. And what we know is that Luxembourg does not recognize alter ego claims. And so none of this should go forward as a matter of law. As a matter of fact, their primary argument about this, and I think that the trial judge recognized this as well, and what Justice Reed did, and I think it really was tried to avoid the thing by arguing that somehow or another we have waived this argument. We did not waive this argument. We expressly reserved the argument in front of Justice Friedman. We did it in front of this court as well. What we were doing is saying we think this complaint will not stand as a matter of law. We don't think they're standing to begin with. We think the claim fails under New York law, but in the event any claims survive, this is a typical way this is done, we're going to raise the Luxembourg legal arguments. We preserve that issue as best you can, saving the judicial resources of all the courts here to not have to delve into something if it was unnecessary, because standing would take care of the case. And at the trial court level, it looked like it did take care of the case. Then we reserved it here, and up at the Court of Appeals, obviously it was not an issue at all. They are outlandishly arguing now that somehow or another the Court of Appeals ruled on choice of law. They were never even presented with choice of law. That was not an issue in its decision. And so what we have here is Luxembourg law is clearly applicable here.
So even if we assume that, right, WTC put in an affidavit from an expert that says that there is under Luxembourg law, remedies similar to alter ego liability, right?
They did, Your Honor.
So we're on a pre-answer motion to dismiss. There's no possibility that that would go away, even if we assume that Luxembourg law applies.
Well, I'm not sure, Your Honor, respectfully again, that I agree with that, because I believe it's the job
You're
of
asking us to evaluate the worthiness of the expert's opinion
what I'm saying is
on a pre-answer motion to dismiss?
there are two affidavits here. There's an affidavit from Andre Prum, our expert, who says that it doesn't exist. And what that should have been done, it's a question of law for the trial judge to do.
I think that you will find many, many cases where there are two experts on foreign law who come to different conclusions, and this court and the Court of Appeals has said that is an issue for a jury to decide which expert's opinion should rule the day.
Your Honor, there's lots of authority out there for trial judges to decide this as a matter of law. It's a legal question, not a factual question, and the judges decide the legal questions. I believe it's a legal question.
Okay, you believe that two experts on foreign law is solely a legal question and there could never be a fact question about that?
I believe, well, Your Honor, if you
I
look...
can tell you honestly that I've ruled myself more than one time
Your Honor, I
that
think
two experts on foreign law that each raise an issue of fact.
I think, Your Honor, you have to look at the affidavits that have been put in here and the submissions, and there aren't factual issues. It's the law. It's cases. Do they say it or do they not say it? Obviously, we're all a little hamstrung here because obviously the Luxembourg law is in French, but nevertheless, we have two French-speaking experts who put in affidavits. I don't want the forum nonconvenience to get lost because I think it did get lost at the trial court level as
You can certainly address it on
well.
your rebuttal.
Thank you.
Good afternoon, Your Honors. David Goroff on behalf of Appellate, Cross-Appellant Wilmington Trust Company. Your Honors took my opening paragraph away. The Court of Appeals already decided this.
I would like you to address the personal jurisdiction argument with respect to the two individual defendants, not the two corporations, but the two individual defendants, Aliberti and Khaleesi,
Right.
specifically.
Absolutely. So,
Assuming, other than closely related, is there any other basis upon which to find jurisdiction over them?
I believe alter ego jurisdiction would be an additional basis that Justice Reed did not feel the need to reach because he believed the closely related was so clear. And the law holds that it is easier to establish personal jurisdiction for purposes of alter ego jurisdiction than it is to establish the claim.
So if there is at least a colorable claim of personal jurisdiction against the corporate defendant, that would also carry over in the event that there was an alter ego liability to the alter ego. That's your argument, right?
That is our argument, and in fact, there are abundant facts, although my colleagues tried to suggest otherwise, tying specifically Mr. Calice and Mr. Aliberti to this. And if I can just address those, because I think it shows the correctness of Justice Reed's decision on personal jurisdiction, these individuals, first of all, they were the head of what was called the deal team for Apex and TPG. So everything from the acquisition of the company to the setting up of the 8 shells that controlled the company to the dividend that they wrested from the company to eventually disposing of the company, they oversaw. With regard to the investment that's at issue, we are the trustee standing up as a judgment creditor on behalf of all note holders. Those note holders were effectively defrauded through an offering memorandum which was done under their auspices. They signed the resolutions that authorized that. They oversaw the attorneys and the banks that prepared that. They also signed the notes and they signed the indenture. They signed, there's what's called CPEX, which is this instrument that was used to do this distribution, this dividend that they took, which they didn't call a dividend in the offering memorandum. And they valued the CPEX themselves. They were told by their outside advisors to get an outside valuation. KPMG told them that. Ernst & Young, their auditor, stood waiting to do that. They did it themselves, and they valued it. They priced the bonds. There's an email in our complaint that's also part of the record that says, we priced the bonds for Mr. Calice. They priced the bonds, meaning the CPEX, I should say. They priced the CPEX at 35 times par. 8 months earlier, they were priced at $1 per par. So 35-time rate of return increase in 8 months. That's 5,250% that Messrs. Calice and Aliberti brought to the table. And then the next week, 10 days later, when they did their year-end financials, when they knew that would get scrutiny, they brought it back down to €1 par per CPEC. Mr. Aliberti and Mr. Calice each received distributions They each made money from the dividend themselves, so they had a personal interest. And while they say they did this in their official capacity—
So may I interrupt you? Assuming that we know what the allegations of the complaint are, well, how do you deal with the breach of contract claim as to the alter egos? You have a judgment. When you have a judgment against the principals, why do you need the breach of contract claim? What's the purpose?
Well, candidly, as Justice Reed said, we're all seeking just one recovery for—
So again, why should we keep the breach of contract claim in?
No, I hear that, Your Honor, and I think it's a slightly different breach of contract than—
How is it slightly different? What are you seeking? The amount of the judgment?
We are seeking the amount of the judgment.
So I think it's exactly the same, right?
In terms of remedy, it is the same, yes. It's another theory toward the same remedy, yes.
All right. But you have the remedy, right? You have the judgment, and you have a claim to get to the remedy.
We have an alter ego claim and an unjust
alter ego
enrichment
claim,
claim,
right?
yes. We have those two, and the court thought we did have a contract claim, but the court recognized that if we won an alter ego, we couldn't also pursue contract. We certainly recognize that as well, but we definitely have colorable claims that allow us to pursue this. That's really what matters here.
Why would you assume that you could get a breach of contract unless you also pled your alter ego claim? You can't.
So I think the proof is the same.
The only thing you need is the alter ego claim, right?
I think you're correct in that, Your Honor. I mean, but the evidence on that, of course, is overwhelming. And it's to Apex New York. In the offering memorandum at page 10, they define Apex. And they say before that, come invest with us. We are sponsors with great experience in the telecom industry. They highlight 8 deals, 4 of the deals, Intelsat, Jamdat, Yell, and I'm missing one here, Audible, were deals of Apex New York. So to get people to invest in this New York governed notes through this New York governed indenture, at the time run by a New York trustee, they said, look at what Apex New York has sold, and look at Apex New York's expertise in this deal. The head of Apex New York, John McGrew, was at the meeting in London where they authorized the dividend. Apex New York is an owner of and partner in Apex London, the investment advisor for the deal. When Apex London gets money and investment advisors don't work for free, Apex New York gets money. And as a partner, Apex New York is part of the deal. Apex held itself out as a global one world company with offices in all the major financial centers. I think all of us would agree New York is a major financial center. Thank you.
Your Honors, just a few brief points. I don't mean to beat a dead horse, but Justice Scarpula, I will just mention that on page 39 of the Court of Appeals decision, the court, in bottom lining why it was permitting group pleading to pass muster in that, with respect to that complaint, said, quote, it would be unreasonable to require greater detail from WTC as to each individual's daily contact and involvement in the fraud at this pre-answer, pre-discovery stage. So my point is simply that even the Court of Appeals—
So then the thing to do is move for summary judgment, right? This is still the pre-answer pleading stage.
It's I can't remember the chronology of the answer, but the point—
Here's what the Court of Appeals said. It is sufficient at the pleading stage that the alleged facts and inferences drawn from them establish the basic elements of the doctrine of piercing the corporate veil. And I'm quoting directly from the last one. So you're saying to me now, they've added in more, and yet at this pre-answer stage, you should, or they've refined it. I don't know if you want to
I'm simply saying this, Your Honor, and again, I don't mean to beat a dead horse. I'm simply saying there's not a single particularized allegation against this entity which was not involved.
So then move for summary judgment.
Well, I'm saying that would be— I don't think they're entitled to get to that stage. I sense that Your Honor does not agree.
Now, I think the Court of Appeals doesn't agree. It has nothing to do with me.
I think the Court of Appeals may have had a different view at the post-discovery stage. That's really page 39. But, Your Honor, let me just make a couple of other comments on what counsel just said. First, on the, he said that Justice Reed did not reach alter ego jurisdiction. He did and specifically rejected it. I would also point out that alter ego jurisdiction under this court's precedents at 8 to 9 of our reply brief focuses on different elements, none of which are alleged or satisfied here by the evidence. And also, there's a fundamental problem with the alter ego jurisdiction argument, which is as follows. There has to be an alter ego relationship at the time that the primary defendant has the jurisdictional contacts with New York. That is not, and we explain at page 9 of the reply brief why that is simply not the case here. And the Williams v. B. Miller case in the Fourth Department that was affirmed by the Court of Appeals is very strong precedent for that. On the Luxembourg law issue that Justice Weber asked about, I would simply say that the affidavits, and I think Justice Scarpulli, you commented on this as well, I think that the affidavits that you're talking about go to not which law governs, but simply what that law is. And I would suggest that they're two separate issues. Whether Luxembourg law or New York law applies is an issue. Then you have the separate issue of what is Luxembourg law, what is alter ego, what is New York law. That's the subject of the affidavit.
And then the judge would make a determination as to that.
Exactly. But in the first instance, the point is that Luxembourg law applies. This is a Luxembourg entity.
Why do you need an expert to tell you what Luxembourg law is?
At the end of the day, assuming Luxembourg law applies, we think the court would need a Luxembourg law expert to tell him what that law is.
Or her.
Or her. Yeah, well, Justice Reed in this case,
No, I know,
yes.
I know.
Yes.
Thank you.
And then last but not least, on the point that Justice Scarpulli just asked about, of course the breach of contract claim cannot stand. As we argue in the brief, it merges into the judgment and disappears. If they have a claim at all, it's on the judgment. We would also urge you to take a look at the a holding by Justice Reed on the scope of the forum selection clause with respect to the judgment enforcement claim. That is an issue of first impression in New York. We think Justice Reed got it wrong and creates a dangerous precedent, because if his holding is not reversed, you'll have a situation where his interpretation with respect to a mandatory forum selection clause will limit a judgment creditor to enforcing the judgment in the forum designated for contract-related disputes.
Thank you, counsel.
Thank you.
Well, I'm certainly not going to repeat anything that my colleagues said about the Court of Appeals decision, but I would say that I agree with them. But without opening a Pandora's box there. But I did want to get to the forum nonconvenience issue, because I think it was just not properly treated at the trial level. The trial judge said two things about it. One, that somehow or another we're not entitled to forum nonconvenience because the case has been around for a very long time, since 2011, and some discovery has been taken. And respectfully, we've cited case law for the proposition that neither of those factors are dispositive or compelling or frankly even fair. It is true that this case was filed in 2011 jointly with another group of claimants, the Cortland claimants. We moved to dismiss immediately. That was decided in 2014. It was then appealed to this court, where the trial court was reversed in 2016. We then went up to the Appellate, to the Court of Appeals in 2018. They amended their complaint in 2019. We moved immediately to dismiss it. It took a while to brief it. COVID hit, et cetera, et cetera. The fact that the case was around since 2011 is true, but that's not a reason not to grant forum.
How about the fact that the judgment is a New York judgment? How about the fact that you've been litigating here in New York? I mean, to show forum nonconvenience, forum non, you have to show super bad tough to litigate here. One, the judgment's here. Two, you have been litigating here for the last 10 years. So it's kind of hard for you to say, it's impossible for us to litigate here when you've been doing it for the last 10 years. And the judgment that we are seeking that is being enforced is a New York judgment. New York has an incredible, intense interest in enforcing New York judgments, right?
And let me, obviously it's a New York judgment.
And two of them are New York, and two of the defendants are New York based, right?
Two of the remaining 12 defendants are
New York based defendants. A New York judgment and litigation for 10 years in New York where no one seemed to not be able to litigate.
And then on the other side of that, Your Honor, what I would put are the other factors that Justice Reed did not address at all, which are that European courts have proven themselves more than suitable to address these.
So what? So is New York.
But that's one of the.
That doesn't tip the balance.
It may not tip the balance, but it's a factor to take into
Okay.
account. There's an alternative forum, and as a matter of fact, there's
Fair
already been a
enough.
trial in Luxembourg. The claimants lost, as Your Honor is aware, and is in the papers here. Luxembourg law will and should govern two.
Assuming that's true, the commercial division judges in New York often apply foreign law, not a problem.
Again, it's a balancing act. You take all
Right,
the factors
exactly.
together.
Still don't hear why we should not
the-
have a litigation about a New York judgment
I've
where
got a-
that
I've-
has been litigated for 10 years in New York.
I've got a list here, Your Honor.
Okay.
The key witnesses are in Europe, outside of the trial court subpoena power, all of them.
Have they been deposed?
Well, they've been deposed, but again, Your Honor, it's a fraud case. We're going to try a fraud case in New York based on deposition testimony. That's pretty unusual. These folks are all in Europe. Mr. Caliche is in Europe. Mr. Aliberte is in Europe. The experts are in Europe. We spent most of our time in London in 2016 and 2017 taking depositions. And finally, there's no connection between New York and the allegations in the complaint. Everything that they're talking about, that all the bad acts that allegedly happened in Europe. Mr. Caliche worked for a TPG Europe defendant. He didn't work for any of the entities that are still in this case. I believe the same is true for Mr. Caliche. I think when you put all those factors together, and I would urge the court to take a look at the Blanco versus Banco case, a strange case, but frankly, the factors, Your Honor, that you just talked about, which is the case has been going on for a long time, you've managed to litigate in New York. There are a couple of entities that are New York entities. Even there, what the Second Circuit said is we are going to affirm a forum nonconvenience dismissal, despite the fact that they had those three because we had all of the others. And so I think forum nonconvenience is an appropriate thing to do with this Eurocentric dispute.
Thank you,
It's been
counsel.
litigated in Europe and it belongs there.
Thank you so much. Hope Investments versus Belmont. Oh, I'm sorry, did you have, I apologize. You have a rebuttal? I apologize.
No problem, Your Honor, and I apologize. Your Honor, if I may, before I begin my cross-appeal portion, just briefly address Luxembourg law.
I did.
Which, the court's reason for not addressing Luxembourg law is that they waived it when they briefed the prior appeal. But there are other reasons. The other reasons are, it's the internal affairs doctrine, and as the UBS case of this court has held, when the internal affairs of a choice of domicile would be prejudicial to third parties, as this would be, then you look to New York. And here, as Your Honors have noted, you have a New York judgment. You have a New York judgment that is uncollectible because of the conduct of the alter egos.
That act happened in Luxembourg. The witnesses are in Luxembourg. So.
No, there's no witnesses in Luxembourg.
I thought your adversary stated that the witnesses were in Luxembourg.
No, there's absolutely none. Mr. Aliberti is in London. Everybody's been deposed. They're in Atlanta. They're in San Francisco. They're in Canada. They're all over the place, but none are in Luxembourg. And Your Honor, briefly on the cross appeal. So the Court of Appeals also said we had a fraudulent conveyance claims under the DCL. And that is correct. You have, again, a New York judgment, a New York notes. You have New York. We are now a New York judgment creditor, and so we have a vested interest in seeing New York law apply. Justice Reed did not find there weren't fraudulent transfers. There obviously were. He just said it required extraterritorial application of the DCL, and that is not true. Because of the context here, it is imperative, in fact, that New York law apply. Again, if you think about it, these investors were recruited with the promise of New York law applying. If it were so easy to say, we said New York law would apply, but it doesn't really apply when the pedal hits the metal because we're a Luxembourg shell. Do no business in reality there, but we're a Luxembourg shell, so you must apply Luxembourg law. That's obviously very unfair, and the whole purpose of fraudulent transfer law, as the court stated in the Advanced Portfolio Technologies case we cite, is to aid specific creditors who have been defrauded by the transfer of a debtor's property. It was enacted to enable creditors to know with certainty that they could rely upon property of their debtors even if situated in another jurisdiction. Furthermore, it is established that New York has an especially strong interest in applying its law when one of its domiciliaries alleges it has been defrauded. So the case for application of New York law here is strong. It's been emphasized by the New York Court of Appeals, which also emphasized that Wilmington Trust Company, which represents all creditors, has the power under Section 6.03 of the indenture to bring these claims, and ended its discussion of why there is a fraudulent transfer claim by saying, therefore, WTC is empowered under Section 6.03 to pursue causes of action to recover pro rata payment for all note holders against those who WTC alleges bled dry the issuer and guarantor for defendant's profit to the detriment of the note holders. Because we know the specific amount of the bonds, Your Honor, $200 million, and we know what became of it, there is also a conversion claim. Thank you very much.
Thank you. Thank you all. Thank you very much. Pope Investments versus Belmont Partners. Justice Owen is recused on this matter.
Good afternoon. May it please the court. Patrick Lawless for the defendants, appellants, respondents, Belmont Partners, and Joseph Muse. The Supreme Court should have dismissed the plaintiff's fraud claim. An essential element of any fraud claim is justifiable reliance. The legal standard when you're dealing with a sophisticated investor, such as we are in this case, is that the investor must show that they took reasonable steps to protect themselves. The record in this case establishes that the plaintiffs took no reasonable steps at all to protect themselves. We have the affidavit of the defendant's expert, Mr. Freeman, and he goes through the type of complex transaction and all the elements that are involved. He discusses the parties involved. It's undisputed that the plaintiffs are sophisticated investors and hedge fund managers that control approximately $500 million. They were represented by legal counsel at all times. They've had vast experience with these types of transactions known as Chinese reverse mergers. And their allegations are essentially that they relied exclusively on Mr. Muse for everything involved in this transaction. Mr. Muse is not an attorney. As explained by Mr. Freeman, he would not be the appropriate person responsible for putting this deal together because it involves very technical, regulatory, legal, and tax implications. And in opposition to this showing, the plaintiffs submit an affidavit from one of their principals, Trent Curry, and all he says is that the Pope the Pope plaintiff conducted their own due diligence, and he provides no explanation at all what that entailed. And then he said that the due diligence also included numerous conversations with Mr. Muse regarding the structure of this deal. Again, with no details, but all at the very most, it shows that they relied exclusively on someone else to do their own due diligence. And for that reason alone, the fraud claim should have been dismissed. On top of that, we have Mr. Muse's testimony, which coincides with the evidence in this case and Mr. Freeman's affidavit, that he was requested to step back and allow the attorneys for the parties to structure this deal.
But I thought that although he was stepping back, that there were affidavits submitted that he was still, that was not communicated, his quote-unquote stepping back.
What Mr. Curry states in his affidavit is that he doesn't recall having that conversation, and he thinks he would have had that conversation took place. He doesn't flat out deny that the conversation took place or was never communicated to him. That's all he says. But again, it would be expected of sophisticated investors to conduct their own due diligence into this transaction.
So, counsel, this is a pre-answer motion to dismiss, right?
I'm sorry?
This is not a motion for summary judgment.
This is a motion for summary
For
judgment.
summary judgment at the end, oh, I'm sorry, you're right, I'm sorry, I'm confusing you with the last one. Okay, so, the plaintiff says, here's the material misrepresentation, that one, Belmont Partners and Muse were going to be intimately involved in all aspects of this very, very complicated transaction. And two, I relied on that, and if they had told me that they were not going to be intimately involved in all stages of the transaction, I would not have recommended it. Three, I suffered damages because of it, because unbeknown to me, the structure that the lawyers put together allowed the third party to abscond with the money, right? And that's backed up with affidavits. Now, you might not agree with the affidavits, and your expert might not agree with the affidavits, but there's an issue of fact there, correct?
I respectfully disagree,
Okay, tell me why.
and that's because, again, it goes to my initial point, that you're dealing with very sophisticated investors. And also, they're conflating and confusing Mr. Muse's role in this
He
transaction.
got paid $1 million, the Belmont Partners got paid $1 million, right?
Yes.
So what do you say? I think that in and of itself says to a reasonable juror could assume that he wasn't paid, the Belmont Partners and Muse wasn't paid $1 million just to put two people together.
His role in this was he was acting on behalf of SMT to solicit investors into the transaction.
So that is not what the plaintiffs say that they were told his role would be, and the Belmont Partners.
That, if they relied upon that, that would not be reasonable, and they didn't do any of their own due diligence.
Why wouldn't it be reasonable for them to rely on the guy who brings the deal to them, tells them, puts together the PowerPoint about the deal, tells them how the deal is going to be structured to see the deal through? Why is that unreasonable?
He's not an attorney. All he's doing is
So what?
He held himself out as an investment banker. He held his Series 7 license. He admitted to owning at least 2 companies, including Belmont, that provided specialized financial services for complex business transactions. And he's the one who's putting together the deal. So again, why would it be unreasonable for them to rely upon his expertise?
because they are sophisticated investors. They have their own, according to...
Sophistication only goes so far. I mean, they do their due diligence. They hire their experts. But their experts are telling them one thing, and this gentleman who brings the deal to them, who also appears to have some expertise based upon what he's stating. So it's a balancing act, is it not?
Not in this case, Your Honor, because...
Or at the very least, why would it be unreasonable to rely upon what he says?
It would be unreasonable for them to rely exclusively on Mr. Muse and not undertake any due diligence of their own. In opposition to our motion for summary judgment, in which we submitted an expert affidavit in which the expert details all the steps they should have taken to protect themselves, they failed to raise an issue of fact. Their affidavit in opposition of Mr. Curry doesn't set forth any diligence whatsoever. He makes general proclamations. All he says is, we conducted due diligence, provides no detail, and then he said we had conversations and we relied on that without any independent due diligence of their own.
Thank you. You have time on rebuttal.
Thank you, Your Honors, and may it please the court. Your Honors,
Given the complexity of this arrangement, why not do a greater job at due diligence?
I think due diligence is a question of fact, and it should be submitted to the jury for a reasonable jury to decide. There's several case law in New York that says that reasonable due diligence, and reasonable reliance is just a question of fact, not to be determined at the motion for summary judgment stage.
I would say that that is not, I mean, that's a gross overgeneralization of the law 20 years ago. I think we do it more, but I do think that, so why isn't it unreasonable as a matter of law for you to have relied on Belmont Partners and Muse advice about the deal?
Because a lot of the information that Muse provided to the plaintiffs, Your Honors, were expressly within his purview, that the plaintiffs did not have access to this information.
What do you think he got paid $1 million for?
He got paid $1 million.
Just to put the two together? Is that it?
No, Your Honors. We believe there are several questions of fact regarding Mr. Muse's and Belmont Partners' involvement in this action. Mr. Muse, in fact, testified, and the record reflects at 139, that he called himself a broker in this transaction. So even during his deposition, he called himself a broker. During the briefings of this case and before this court and at the motion for summary judgment stage, the defendants have claimed that they did no due diligence and claimed themselves to be complete novices. This admission of gross negligence is enough to create a question of fact for a jury to decide that Muse told the plaintiffs that he was acting as, with his Series 7, that he was acting as a broker for this transaction, but yet did not relay to the plaintiffs, that he didn't undertake any investigations, that he did not do anything. All of this information is expressly within the purview of—
I'm sorry, you were arguing that the defendants themselves did not do any due diligence as to Muse's expertise?
No, excuse me. The defendants claim that they did no due diligence in this action.
Oh, you're saying, right, because they were asked to step back and the lawyers were supposed to do the due diligence.
Right, but there's a question of fact as
Does
to
the
whether—
do the lawyers agree to that? Agree that the defendant, did you take the lawyers' depositions?
I was not with the firm at that time. I know Mr. Curry's deposition was taken. Mr. Curry was, in fact, intimately involved in the details of the action. He expressly states that the Belmont defendants did not inform him or anybody else at the Pope that he would not be involved in structuring the transaction. The
Are there any documents that say that only the lawyers would structure the transaction and do the due diligence?
No, there is not, Your Honor. No,
there are emails, right? There are emails in the record.
Yes, there are emails that go back and forth that talk about the structuring of the deal, but there is no email, no nail in the coffin that specifically says that Muse will be stepping back and he is not involved.
So there are no emails in which he told the plaintiffs that, I don't know what you're talking about, I'm not the deal guy.
Correct. It's all a question of fact for a jury to decide what his role in the transaction was. And then in regards, if I may, Your Honors, in regards to plaintiff's cross-appeal regarding the preclusion of Mr. McMullen's testimony at the motion for summary judgment stage, it was an error for the trial court to disregard the testimony of Mr. McMullen. There's clear questions of fact. The trial court even admits that the relationship of Muse to this action is a question of fact and unknown at the time. She did proceed to preclude Mr. McMullen at the motion, but however, in the order, she specifically tasked plaintiffs with informing her why her decision was wrong and why Mr. McMullen should be included. Plaintiffs succeeded, and the court, during the motion in limine stage, ordered that she would mark up Mr. McMullen's testimony, and so it was an error and premature for the court to preclude Mr. McMullen at the summary judgment stage. Do Your Honors have any other questions?
No, thank you very much. You do have time on rebuttal, though.
I'd just like to go back to the issue of justifiable reliance, because there's no issue.
What was he being paid the $1 million for?
The $1 million has nothing to do with whether or not the plaintiffs could have justifiably relied on his representations or absolved them of their own duty to undertake due diligence. There's not a shred of evidence in this record that the plaintiffs undertook any due diligence whatsoever. It's not an issue of fact whether the due diligence, that they undertook due diligence and whether that would have been enough. They admit that they didn't do any due diligence at all. They just make very vague statements that they performed due diligence and provide no details, and then Mr. Curry states that it was numerous phone conversations. A key fact, which was admitted by Mr. McMullen, is that they have their own investors, they have their own legal obligations to these investors, and they have their own contractual obligations to these investors to conduct due diligence. He even admitted they had a duty to conduct due diligence. He couldn't say what it was because he wasn't intimately involved in this deal, but there's no evidence in this record of any due diligence at all. That's why the fraud claim should have been dismissed. It's not an issue of fact. They're saying they relied exclusively on Mr. Muse, and the case law is clear, going up to the Court of Appeals decision. The case law is clear. If you are a sophisticated entity, you cannot allege a fraud claim without showing that you took any reasonable steps to protect yourselves. There's no evidence that they took any reasonable steps to protect themselves.
Could it be the reasonable step is that they relied on that they probed and spoke to on a daily, weekly, bi-weekly basis the people who brought them the transaction and told them that they were experts at it and were going to shepherd them through it?
This is a person that they've never done business with before.
I know, I understand, but assuming that, that's what they
No,
say.
According to the
That's what they
case,
say. That's their affidavit. That's literally what he says in his affidavit, right?
according to the case law, that's not reasonable.
It's not reasonable to...
It wouldn't be
to
reasonable for them to
rely
even
yourself
investigate Mr. Muse to see what his level of expertise is in the first place. They didn't even do that.
He held himself out as an expert. He just said he was not an expert perhaps in Chinese mergers, but he was an expert in everything else.
So if someone holds themselves out to be an expert, you hand over $12.5 million and don't do anything else to protect that investment? That's what happened here. They didn't do anything.
Well, I think the point was that they're arguing, or at least there's an issue that they did. And also your adversary made reference to certain information that only Mr. Muse was privy to.
No, it's not information that Muse was privy to. There were public filings with the SEC that disclosed all the parties involved. According to Mr. Freeman, it's customary for sophisticated investors to investigate all the parties involved in a transaction like this, especially in an emerging market like this. And again, they didn't do anything. You can't point to anything in this record that shows that they undertook any due diligence whatsoever.
Thank you.
Your Honors, the plaintiffs absolutely did their due diligence in this matter. Every instance of this transaction was discussed down to the minutest of details. Mr. Muse absolutely held himself out as an expert. He appeared on CNN and MSNBC.
So I'm sorry, you're conceding that you did no due diligence?
No, we did.
Oh, I thought you said the plaintiffs did not. I'm sorry.
I'm sorry. If I misstated that, I apologize, Your Honors. But at the time in 2008, Defendant Muse was appearing on national television, holding himself out not only to the plaintiffs, but to the world as an expert in transactions like this. To claim that plaintiffs did no due diligence is frankly inaccurate. It's an inaccurate reflection of the record and the things that were occurring in 2010. In regards
$1 million.
I'm sorry, what, sir?
$1 million, is that relevant or not?
Oh, it's absolutely relevant. In addition to Mr. Muse stating that he was the broker in the transaction, he did receive $1 million, which is the largest cut that anybody received from the transaction. In addition to that, Mr. Muse, the defendants argue that Mr. Muse and Belmont Partners stood to gain significantly had the transaction been successful. However, what all reasonable inferences taken in favor of plaintiffs, had the defendants told plaintiffs the truth that they were inserting this third party that they hadn't done any due diligence on, the plaintiffs would have pulled out of the deal. So defendants stood to lose significantly had they told the truth. So the story proposed by defendants is supposed to be viewed in the light most favorable to plaintiffs, which is what the trial court did. They viewed all of the facts in the light most reasonable to the plaintiff and held that a reasonable jury could find that the reliance on Mr. Muse and Belmont Partners at the time of the transaction was reasonable. At this point, it is just a question of fact for the jury to decide what was reasonable and what was not. The question of due diligence is a contributory negligence question, again, for the jury to decide. Stating that no due diligence was done is false and not supported by the record. Whatever due diligence, that the plaintiffs conducted, the jury should decide if that was reasonable or not.
Thank you. Thank you both. DeVita versus New York Steak, Manhattan. No. Well.
May it please the court, my name is Scott Singer, and I represent the plaintiff appellant, the estate of Kevin McConaughey. The court dismissed this complaint in its entirety, and we submit that there were, in fact, valid claims under Labor Law 240, Labor Law 241-6, Labor Law 200, and common law negligence. So I'd like to begin with a brief discussion of the 241-6 claim. Now, I want to emphasize that the defendants have not actually disputed the fact that plaintiff had a valid claim under Labor Law 241-6. Plaza's brief is entirely silent on the issue. Baring takes the position that they're not liable under 241-6, they're not a proper labor law defendant, but they don't dispute that this is a valid claim under 241-6. B&G also is totally silent on the issue. The only one who raises an issue is Day and Night, but Day and Night expressly waived its right to contest plaintiff's liability under 241-6 in Supreme Court. It did not dispute, it did not submit papers in opposition in connection with plaintiff's 241-6 claim. It did not seek dismissal of plaintiff's 241-6 claim. So we submit that there's absolutely no basis for the court's dismissal of the 241-6 matter. But I would like to very briefly talk about the merits of that. We alleged two specific mandates of the industrial code. One is section 23-1.30, which requires that lighting be adequate for a proper job site. In this case, there was a lot of evidence. The plaintiff said that the work area, the area where he fell was dark and cluttered. When a Day and Night's witness characterized it as mediocre at best. And B&G's, Day and Night's forum said it was very dim. And Plaza's own witness acknowledged that there was no lighting in the immediate area, there's no lighting over the elevator pit, and there was no lighting in the adjacent hallway. The nearest string lighting was some distance away. So it was a very dark area, and under Emory and other cases that I cite in the brief, there's at least a question of fact as to whether section 23-1.30 was violated. The other regulation, 23-1.7e, the tripping hazard regulation, was surely violated here. There was an obstruction. There was a piece of wood in the hallway that plaintiff tripped over. A hallway is a passageway, this court has held, in the Quigley case and other cases. So any kind of obstruction in a hallway that causes a worker to trip is a hazard and is actionable under Labor Law 241-6. I want to deal briefly also with plaintiff's Labor Law Section 240, sub 1 claim. And I want to, Day and Night cites the case of Salazar, which is, the court is aware, was a case where there were openings in a basement floor, and the Court of Appeals ultimately decided, well, there's nothing you could, it was reasonable to expect It was not reasonable to expect those to be covered because there was active work occurring in those openings. So you couldn't cover them up because of the nature of the work that was being performed. But in this case, there was no work on that large elevator pit opening. There was no work in progress, and I think the daily, the job reports and is also interpreted by Mr. Rusher, who is the...
I thought it was being used as kind of like a storage area.
Yeah, well, storage area, I don't think that's the kind of work that they're talking about where you actually have to use that as...
But if you look at the pictures, I mean, there's like heavy, large machinery or something in that area.
Yeah, the electricians were using it to store, but they could have stored it somewhere else.
Yeah.
It was not necessary.
But I think the bottom line was that there was testimony that that pit had been covered and that it should have been covered, right?
That's absolutely. Mr. Rusher conceded that it should have been covered. I just wanted to cite the case of Diaz against City of New York, where this court stated, Salazar does not buy recovery, whereas here, work in the opening had not yet commenced at the time of plaintiff's accident. So that's Diaz against City, 110 AD 3rd, 577. Also a case Demetria that followed it. And as far as the depth of the opening, very much in dispute.
Yeah, that's an issue of fact, right? I think your client said it was, what did he say, it was 18?
He said it was 2 to 3 feet.
2 to 3 feet, somebody else said it was 18.
Yeah, Mr. Chin said it was 2 feet, there was some testimony it was 18. But I'd ask the court to take a look at the photograph at 2273, and I looked at it pretty carefully. You see a bucket, an overturned bucket, it's 5 gallon there, 12 inches to 14 inches typically. This was only about half the size of that opening.
But what I did not see was any type of measuring apparatus.
I wish there was.
I would have wanted to see a little ruler or yardstick that would help me to see how.
The de minimis ruler, come on,
I think the closest we come is, and I checked on Google, a 5-gallon bucket is typically 12 to 14
Well, then you have
inches.
to do the math, right? You got to figure 5 gallons and convert it to.
No, I didn't do the math, I just looked at
That was the point. That was the point. You were requiring us to do the math.
Yeah, I just looked on Amazon. But it looked like it was half the distance. So at the very least, there's a question of fact as to depth. I'm going to reserve the rest of the points to...
Well, you ran out of time anyhow.
I'm out of time.
But thank you for reserving the time you ran out of.
Thanks.
Reserving time.
Good afternoon, Your Honors. Kevin Pollack on behalf of New York Steak, NYY Steak, and Plaza. Just a quick thing, the plaintiff is only looking for reinstatement of his claims. There's no issue here in terms of judgment in favor of the plaintiff, just reinstatement. And for that reason, we did not oppose that portion of the plaintiff's appeal regarding reinstatement of the 241-6 and the 240 claims, since we didn't oppose their dismissal. We do believe that the lower court's order should be affirmed with respect to the 200 and common law negligence claims. With respect to the lighting issue, Plaza's super, Mr. Usher, testified that the lighting was adequate. He was able to see where he was walking. There were no complaints made to him before the accident regarding the lighting being inadequate. The employer's project manager, James Vespi, said he never complained about the lighting as well.
But at the very least, don't we have an issue of fact as to the lighting? Because it's back and forth. Some stated that it was adequate, some stated that it was inadequate, some stated that it was poor. I mean, we're back and forth, so I would think that there's an issue of fact.
You have a bunch of adjectives, but nobody said they couldn't see what they were doing. So the fact that you mentioned, I don't believe there's any testimony that there's a complaint of it being inadequate. Most of the witnesses, except the plaintiff, who used an adjective that it was dark, indicated that you could see what you're doing, you could see what you're walking, and the lighting was sufficient for the work that was taking place. So we believe in terms of that.
But let me just ask you, didn't the plaintiff testify that he couldn't see?
He was walking backwards.
Right, and he said it was dark and I couldn't see what was there.
I don't believe any testimony from the plaintiff that he could not see where he was walking because it was dark.
Oh,
I do not believe there's that
I
testimony.
think I read
thought
it.
there was
but-
something in the record that said there were string lights and that the area that he was traversing did not have the string lights. Did I read that wrong?
He said the first hallway had artificial string lighting that was not very bright, intermittent and dark. He did not see any lighting in the second hallway and had difficulty seeing where he was going.
I believe there's testimony that there was lighting in that hallway, and...
That's the plaintiff's testimony.
Okay, okay. Again, but I don't believe there's testimony that nobody could see what they were doing. With respect to the other issue, which is the 2 to 3 inch by 3 to 4 inch little piece of wood that he stepped on, again, we believe the court correctly dismissed the 200 and common law negligence claims with respect to that. The plaintiff and his foreman did a walkthrough of the area right before the accident. In addition, they both brought materials down into the basement, which brought them past the elevator pit, and the plaintiff never saw any debris of that small piece of wood. There were no complaints to Plaza regarding any piece of wood, and there's no claim by the plaintiff that the defendants created any of these conditions, given the fact that there's absolutely no evidence in the record and there's an abundance of First Department cases that say so, since there's no way for the plaintiff to have, you can't prove constructive notice since there's no evidence how long it was there, and plus when the plaintiff went by the area right before the accident, there's no indication that that piece of wood was there at that point. And with respect to the pit, that pit was covered when it was created. It was a heavy cover, had planks and plywood, I believe it was. And again, prior to the accident, there was no complaints to the defendants about that being uncovered. The mere fact that it was uncovered at the time of the accident doesn't establish negligence against the defendants.
It doesn't? It's okay for it to be uncovered? Where
it was being
covered, it should be covered, but it's okay.
It can't be covered when it's being used, and it was being used as a storage area. And yes, if something's uncovered because it's needed to be used for storage, to something come in, something come out, the fact that it's uncovered for a whatever amount of...
Then that begs the question, then why weren't there barriers put up, right? I mean, just by what you're arguing, that it was uncovered because it was being used for tools, then why weren't there barriers put up, or at least something there?
Or some kind of warning or something being used for storage or something.
Well, I mean, no, like I said, the plaintiff was aware of that pit area. They walked by it right before the accident, and we submitted that the cover was a sufficient barrier to protect the opening when it was...
But the barrier wasn't there. I mean, the cover wasn't there, so there was no barrier. It was just left open, right? I mean, so he's walking backwards, I mean, I don't know, if he's not going to remember every single place of where he's going, right? He's walking backwards.
Thank you.
Thank you.
Good afternoon, Your Honor. William O'Connell for the defendant respondent Bearing. My client was a subcontractor, and a subcontractor can only be a statutory agent in New York if they obtain and retain the authority to supervise and control the means and methods of the work or safety practices at the site. My client did not obtain or retain either of those authority in that instance, and therefore they're not a statutory agent as a matter of law.
So what is your contract with Plaza state?
Our contract with Plaza says in section 2.2 on page 1731, Bearing shall undertake and complete the work under the direction and supervision of and to the entire satisfaction of Plaza and the owner. Thus, in that state, I'm sorry.
Go ahead.
In that statement, the owner and Plaza have retained the plenary ultimate authority to supervise and control the work and safety practices.
Doesn't it also state that Bearing is to supervise and control the installation of kitchen equipment and obligated to exercise such supervision over its subcontractors, including the decedent's employer?
Bearing is in the contract also given general supervision rights in the contract, but that's different when the owner and the construction manager also retain and say, we are holding that ultimate authority. general supervision, as we all know, is really not enough under the labor law, and that's what was done here.
So you would have liability then, I'm sorry, you would be a statutory agent for purposes of 241 and 241-6, right?
I'm not a statutory agent, yes, under those circumstances, because in this case, I argued the Weber versus Baccarat case 10 years ago here, and it was the same thing, where the middleman subcontractor, he doesn't get full authority from the owner or the general contractor, but he does subcontract it down the line completely, and the employer solely supervises or controls the work. And in that case, unfortunately, in Weber, they said the middleman subcontractor is a statutory agent. But in this court, in Keenan, you came to the opposite decision, and I think correctly, based on the rationale that plenary authority was not initially given to that middleman subcontractor. And it makes sense, going back to Russin. Russin said that if the general contractor delegates the work to a subcontractor, then that subcontractor necessarily gets concomitant authority. But they never discuss what happens if it's transferred even further, or if the owner withholds some of that supervision and control. And in this case, that's what happened. I see my light going on, so I just want to say Keenan obviously is the case here. If you just say, well, Russin and all the other cases that plaintiff cites stand for the proposition that the middleman is always a statutory agent, then this court in Keenan was wrong, and I don't believe they were. The other cases, they're clear where the middleman subcontractor does have authority. The contracts either show it or the facts show it. On the 240 issue, Your Honors, I believe obviously there's a range in distances in the thing. I don't believe it was elevation related. I put 18 inches to my suit pants this morning when I was in my office, and it's right below my knee. And if you talk about the Topher case, the one where it's the back of a pickup truck, you're talking knee-high, walking down a flat hallway. That's not a physically significant elevation differential within the meaning of runner, the classic case now on de minimis type of distances. The labor law 241 and 200, I can just say easily, again, we're not a statutory agent, we're not a labor law defendant, we're a subcontractor, and therefore the claims against us under 241-6 and 200 aren't valid because we did not have the authority to supervise or control. And there is part of Russin which says you do have to have supervision and control to have a responsibility. We don't have the responsibility in this case because we didn't have that. We were not on site, we were the middleman, and that's really all I have to say unless you have any questions, Your Honors. Thank you very much.
Thank you.
Good afternoon, Your Honors. May it please the Court, David Larray for Day and Night. I'll be very brief, just to clarify one misstatement in plaintiff's brief and in his presentation on appeal. Day and Night did indeed move for summary judgment in the lower court. It was in connection with the third-party action. We did also indeed oppose plaintiff's summary judgment motion in the lower court and did indeed address the substantive arguments raised by plaintiff with respect to the labor law claims. We adopted and incorporated those arguments already made by the direct defendants in opposition. And so it's not as if these arguments substantively in terms of the 241-6 and the industrial code claims are new on appeal. These are arguments that were fully briefed below and responded to by Mr. Singer and plaintiff's firm. So there's no prejudice. I, of course, respectfully remind the court that it is, of course, entitled to search the record and make its own decision on the merits of these claims. Briefly, also as a third-party defendant, I do have the right to, I do have standing to address the other claims in the case. Last thing I'll say with respect to 240, I asked the court to take a step back and take a look at the totality of the circumstances. I submit that this cannot possibly be a case that 240 was intended to apply to. A man walking down a hallway with an exposed elevator pit that was actively in use to store equipment. If there's no questions, I'll rest. Thank you, Your Honor.
Wait, you're saying that someone falling into what he testified to as a 3-foot pit that doesn't have any barrier around it and the person who is responsible for it admits was covered, doesn't even raise an issue of fact as to whether 240 applies?
And, you know, just to be clear, we're on a construction site, right?
That is absolutely
Okay,
true.
I just want to make sure we're not walking down the street.
Of course
We're on a construction site. So if this is not a 240 case, a labor law case, what would it be covered on?
I would submit that it is a case that stands for the proposition that's well settled in this court and in New York State as a whole, that not every worker who falls at a construction site, not just on the ground, but due to some form of elevation, triggers the protections of the statutes. The courts do recognize that although a worker falling at a site can indeed frequently trigger the protections, there are circumstances.
So what do you think the circumstance here that is here that takes it out? As a matter of law, not as a matter of fact.
Matter of law, it's a normal and ordinary hazard of a construction site.
To have an open pit, an uncovered pit? Really?
Under the circumstance, the precise
So then we
fact.
have an issue with construction sites then. If that's a normal, everyday practice, then I think we're in a lot of trouble.
And it can't be normal because you have testimony here that says that we cover the pit. So how is not, it's not a normal, you know, you got these contradictory facts
Just because
there.
a pit is covered at one point in time doesn't automatically.
There's a reason why it was covered, is because individuals could fall into it. But thank you very much for your argument.
Thank you, Your Honor.
If Your Honors, please, my name is Ed Guardaro. I represent third-party defendant B&G. I'm sorry. Very rapidly, I won't repeat anybody. I'll just try to answer some.
Keeping here, Mr. Singer, longer than he wants to be.
Answer some of the court's questions. With respect to the speculation about the height of the pit itself, I think the plaintiff testified, and I'm sure the plaintiff testified, that after he ended up in the pit, he was sitting on the edge of the flooring of the cement floor, and his feet were on the floor of the pit. So
He testified it was between 2 and 3 feet. That's what he said.
he testified that he was sitting
And
on
if
the
you
edge
look
of
at,
the
right, and did
platform.
he not testify that it was between 2 and 3 feet?
Your Honor, he guessed that.
Yes, but that's his
testified that,
testimony.
okay.
You might not like it, you might think it's BS, but that's what he testified to, right?
Legal term BS, I like that new legal term BS.
I would
Not
just
like-
say
I
that.
mean, that's what he testified to.
Right, and based
And then I
on-
look at the picture, which is the worst picture in the world. I couldn't possibly tell how far. We don't have the de minimis, right? What we would usually see in a case like this where someone was arguing for a de minimis difference is a little ruler that showed like 1/8 of an inch or even a foot. But we don't have that. We have a grainy picture that there's zero possibility of telling what it is. We have one person saying it's 2 to 3 feet, another person saying max 18 inches. Do you see where I'm going with this? There's no
absolutely, Your Honor.
possibility of deciding that on summary.
Absolutely, Your Honor. But if I may, I'll get to another question that the court seems interested in, and that is this an uncovered pit, and is it a dangerous hazard? And I would submit to the court, most respectfully, it's not. He didn't, this plaintiff talks about walking backwards. He twists and he hurts himself, and he ends up in the pit. If I can be demonstrative, I'm sorry. The point is that he doesn't get hurt from being in the pit, from ending up in the pit on his feet. He gets hurt from twisting.
So even if he's walking forward and he falls into the pit, that still would not negate negligence, right? That would just perhaps be comparative. If in fact he tripped over an object which caused him to fall into the pit, again, walking forward?
Your Honor, all of the cases that are cited in these all talk about either a much deeper fall, whether it be feet or whatever, or that the plaintiff, the injured party, was working on top of this.
Right, so that's why we need Judge Scarpulla's ruler. Thank you so much.
If I may, that's why I would suggest the plaintiff's testimony about him sitting on the edge of the concrete flooring might help. Thank you very much, Your Honors.
Thank you.
Sorry, Ed, I lost track of the number of respondents here. I'm going to be very quick. As to the 200 claim, plaintiff's, Mr. McGonigal's testimony, page 311, did you have any difficulty seeing anything? You were looking over your shoulder? Yes. Did you say anything to anyone at the time about having difficulty? I'm sure I mentioned it. The job site was cluttered and dark, and there was stuff everywhere. How long was this condition in existence? According to Julian Gomez, plaintiff's foreman, or decedent's foreman, he was there for 2 days and he'd never seen the pit covered. So it was that length of time. Also, as to the matter of constructive or actual notice, Plaza's workers were in the site that morning. They were moving the dumpster away from the area that Mr. McGonigal had to traverse. They were there that morning, and there was another laborer that was there that reported the accident. So they had noticed, they knew the condition, they were aware of it. As to the remaining issue about Baring's liability, Weber v. Baccarat is controlling. Counsel may wish that it wasn't the law in this jurisdiction, but it is the law, and the Keenan case is distinguishable. That involved very different contractual provisions than are at stake here. Many cases, in accordance with Weber, what he calls the middleman is going to be liable. He's delegated responsibility, and he demonstrates, or he or she or it demonstrates that power by hiring somebody else to do part of the work. So they had plenary control over that. If there's no other questions, I'm going to end about a few seconds early.
Thank you very much.
Thank you. Thank you, Your Honors. I totally got mixed up with that.
How many are there, man? How many more are there?
So do you root for Arizona?
Yes, secondary. So I become a fan.
You know, I'm so disgusted with that whole conference for the U.S. I'm so upset about that. I can't see myself to watch them.